Today I'm going to speak about Bareboat Charter. Bareboat Charter, yes, we will see and we will talk a little bit about content of Bareboat Charter in national and also in autonomous legal sources. So the aim actually of this presentation is to present national and also autonomous legal sources related to Bareboat Charter. So in this presentation, actually our scope will be to present and to analyze rights and obligation of each contract party. And also we will talk a little bit about issues of the contractual responsibilities. So as a good example of national legal sources, I will actually use provisions from Croatian Maritime Code, because in our Maritime Code we have few provisions, actually 14 provisions about Bareboat Charter. But also I have to say that when it comes to Bareboat Charter, also we have to use provisions from our Lex Generalis legal source for all such issues that have not been covered in Maritime Code. So our Lex Generalis in this field is, of course, Croatian Obligations Act. And parallel, we will also see provisions from BIMCO's standard Bareboat Charter forms. BIMCO's, it means Baltic and International Maritime Council. And we will see provisions from the standard Bareboat Charter form with the code name BERCON or standard Bareboat Charter. So today, actually the latest edition of this standard Bareboat Charter form is BERCON 2017. And also in practice, parties usually use and the BERCON 2001. So these two standard Bareboat Charter forms are well-known forms, and they are really in use when it comes to Bareboat Charter. So in this presentation, after introduction, I will explain who are the Bareboat Charter parties, and then we will continue with the rights and obligations of the Bareboat Charter parties. We will start with the owners, rights and obligation, and then with charterers obligation. Of course, what is obligation for one party, that is right for the another, and other way around. And then we will continue with the question of responsibilities of the parties. And again, we will start with the owner's responsibility and then with the charterers' responsibilities. And then in conclusion, I will summarize the above. So first of all, Bareboat Charter is one of the legal forms of charter parties. So there are three types of charter parties. One is time, then voyage charter, and Bareboat Charter is one of them. Bareboat Charter is also a lease agreement. What does it mean? It means that charterer obtains possession and full control of the vessel along with the legal and financial responsibility for that vessel. I have to point out also that Bareboat Charter is really different from the other charter parties. So it is different from time charter, it is different from voyage charter, of course, and it is also different from the other seagoing vessel exploitation contracts, such as, for example, contract for carriage of passengers or contract for towage as well. So why it is different? First of all, mainly because of its specific legal nature, because Bareboat Charter is contract for use. And also it is different because of complex structure of relationship between the parties. So what we have in this case, so as the vessel is delivered to the charterer for the use, so let's imagine that this one is a charterer. So the Bareboat Charter becomes the basis for the charterer's performance of seafaring activities. So the charterer, he becomes a ship operator, and that is what is specific in this legal contract. So charterer, now he is ship operator, and he can use vessel, and how he will use the vessel, of course, it depends, first of all, at the type of the vessel. So there are different, of course, types of the vessel. So each of these vessels, of course, can be subject of Bareboat Charter. Plus, Bareboat charters are used in these circumstances. So by ship owners that need to supplement an existing fleet. So let's imagine that this is the ship owner's fleet, and he would like to supplement an existing one. So maybe to buy a new ship is really expensive for him, or maybe to build a new ship is also expensive. So bareboat charter is good opportunity to supplement an existing fleet, and now he will have total control over that vessel. Also, let's see some bareboat charter basics. So once the charterer takes possession of the vessel, he becomes entirely responsible for that vessel. So what does it mean? It means that he will be responsible and for vessel's crew, and for fuel, for insurance, and for any maintenance and repairs the vessel needs. On the other hand, in exchange for this use of the vessel, the owner will receive a monthly hire. Hire doesn't have to be monthly, but usually in practice it is. And also, once the bareboat charter has expired, the charterer will redeliver the vessel to the owner in same condition as the vessel was originally upon delivery. But of course, we have to have on mind that ordinary wear and tear are accepted. So I have to point out also here that there is no uniform international regulation of the bareboat charter, such, for example, we have for carriage of passengers or for carriage of cargo. So there is no uniform international regulation, but we have national legal sources as well. We have autonomous legal sources. As I said, in our country, we have our Maritime Code, and around 14 provisions between these numbers are dedicated, and they are under title Bareboat Charter. So 14, it seems that is not a lot, but I think it's quite enough for this contract, because we have in practice use of internationally accepted forms. So I'm talking about autonomous legal sources such as BERCON, such as BIMCO Standard Bareboat Charter Form under code name BERCON. So BERCON 2070, it is the latest one. Before that one we had BERCON 2001, then BERCON 89. Which one will party use? It, of course, it depends on them. I already mentioned who are the bareboat charter parties, but once again, so we have an owner on one side and bareboat charterer. I think it's better to say bareboat charterer than just charterer, because when we use the term charterer, then it could be a party in time charter or voyage charter contract. But when we say bareboat charter, we know that we are talking about bareboat charter. So according to the standard BERCON form, parties are owner and bareboat charterer, and this term owner actually means the person registered in the ship register as the ship owner, of course, and in addition to ship owner, also and mortgage creditors may also be lesser. On the other side, so who is the bareboat charterer? First of all, this term means the user of uncrewed vessel. So it is the person that intends to get engaged, or maybe it is the person who has already been engaged in shipping but owns the tonnage that is not sufficient for its business and therefore wants to increase it. Simply in our BERCONs in standard form, we can see on first page boxes for details about parties, about owner and about bareboat charter. So these terms, owner and bareboat charter, simply designate the parties entered in the corresponding box on the first page of the contract form. So contract, the standard contract form is usually with this box laid out system on first pages. Actually, first part is with the boxes, and then second part and other parts are with clauses. So each clauses has a title or name. So let's see a little bit content of the bareboat charter in autonomous legal sources as well in national legal sources. Or let's see some rights and obligations of the parties. So the terms of bareboat charter will depend on the number of occasions. In most cases, these occasions include, for example, purpose of the charter, then charter period, of course, type of the vessel, and also trade involved. And I have to say that there are certain conditions and terms that are fundamental for every bareboat charter. For example, all bareboat charters will have specific details about where the vessel can go. So I'm talking about trading warranties. Also, all bareboat charter will have specific details about type of insurance the charterers must carry while operating the vessel. So I'm talking about insurance warranties. Also, bareboat charters will have another clauses applicable to safe operations of the vessel, such as crewing standards, permitted cargoes, and indemnity agreement as well. So this is what makes this contract special. Let's see some owners' rights and obligations. I would like to start with the owner as a first example of content of bareboat charter parties. So first of all, the obligation of the owner to deliver the vessel to the charterer is defined, of course, in the first place. But in addition to this, the owner, he has also and some other fundamental obligations, such as, for example, to bear specific ship repair expenses, and also the principal obligation include and the vessel redelivery procedure after the contract termination. But let's see some specifics about delivery of the vessel. In Berkon, there are so many details about this obligation of the owner. I was so impressed when I was reading this form. So everything is actually in it. So according to these examples, the delivery of the vessel, of course, means the delivery of possession of that vessel. So after delivery, that vessel will be under full control, and it will be to use on the side of charterer. So the possession actually means full control of the vessel and freedom to use that vessel in compliance, always with compliance with the contract. So, according, for example, to Berkon, the vessel shall be in full possession and at the absolute disposal for all purposes of the charters and under their complete control in every respect. That is according to Berkon. I just want to mention that Berkon use plural for these names of the parties, so you can see that there is a term owners and charterers. Of course, we can have one party on each side, but just to mention in this part. So, according to Berkon, the vessel shall be in full possession and absolute disposal for all purposes of the charterers under their complete control in every respect. According to, for example, to Croatian Maritime Code, the owner's obligation is to deliver the vessel to the charterer in such condition that it may be used as intended under the contract or according to its intended use as well. Also, what we can see from the Berkon standard form, the owner shall before and also at the time of the delivery exercise due diligence to take a vessel seaworthy and in every respect ready in hull, machinery, and equipment for the services. So there are so many details about this owner's obligation, obligation to deliver the vessel. Also, when we talk about this clause, the delivery clause, it is of course important where is that delivery and at what time is that delivery. So the vessel will be delivered to the charterer at the contracted place and at the contracted time. So according, for example, to Berkon, the vessel shall be delivered by the owners at the port and place indicated in box in first part of the contract in such ready safe berth as a charterers may direct. Plus, it was interesting also for me to see this one. There is also one provision in BERCON. According to this one, the vessel shall not be delivered before the date indicated also in one box in first part of the contract. So it means that the place and the time of the delivery is really important. So it's not even possible to deliver the vessel before the date which is indicated in standard bareboat form. Of course, this is just one owner's obligation. Of course, he has so many others. For example, he is also obliged to take over the vessel after the bareboat charter termination. So after the termination of bareboat charter, the owner is obliged to take over the vessel. His obligation at the same time is also in his right. So what we can see, for example, about these obligation of the owner from the BERCON. For example, in BERCON there is one provision. According to this one, at the expiration of the charter period, the vessel shall be redelivered by the charterers to the owners in such ready, safe berth as the owner may direct. So a lot of details really in the standard form are about delivery of the vessel. On the other side, of course, and the charterer, he has so many obligations. For example, let's see some principles, some fundamental obligations. So the charterer's principal obligations are the following: to take over and to use the vessel, then to settle the operation and maintenance costs, of course to pay the hire, of course to return the vessel in same condition as it was found at the time of delivery. So maybe this close payment of hire is most interesting one. So let's see what kind of provisions about payment of hire we can find in Croatian Maritime Code. So according to Maritime Code, the hire shall be paid 1 month in advance, calculating from the starting date. Of course, this provision from Maritime Code is optional, and parties, they may set another time limit to this respect. This clause, according to this clause, the beginning of the hire payment is calculated from the day of delivery of the vessel to the charterer. But of course, parties, they may contract another date as the starting date. I mean, this is a contract, so it depends on the parties. Also, the value of hire shall be set out by the parties in the contract. Usually in practice and normally the parties, they set out total hire as a lump sum for the duration of entire charter period, provided that the charterer shall be obliged to pay the contract sum in monthly. So usually is in monthly payment. So according, for example, to BERCON, the charterers shall pay the owners for the hire of the vessel a lump sum in an amount which is again indicated in one box in first part of the standard form. It is actually box 22, which shall be payable not later than every 30 running days in advance. So in this provision we can find few key words. So there's a lump sum, then payment should be paid every 30 running days plus in advance. In practice, on the other hand, we have so many problems and actually with this clauses, with this higher payment clause. So the most common problems with payment are usually irregular payment. It means that charterers are usually late with the payment. So first problem is delay in payment, and another problem is payment of smaller amount of money. there are even situations in which from one bank account to another, between these transactions, money is lost somehow, somewhere. Same happened in one case called Jonathan. So this was the vessel in Bareboat charter. So the parties, in this case, the parties have agreed on a lump sum payment, but in this case, the charterer, first of all, he was several times late, so not one, he was several times late with the payment, plus he did not pay the exact amount of money, but usually between $5 and $10 less. Of course, $5 to $10 is not too much, but it was the reason for the owner to terminate the contract. So in this case, it was questioned whether the payment of slightly smaller amount of hire, is it a reason for terminating the contract and to withdraw from the contract? At the end, court said that the same right of the owner to terminate the contract, it was stipulated in the contract, because these charterers acting, it was not compliance with the higher payment clause, because according to higher payment clause, he needed to pay hire on time and without any discount. So the court said, okay, this is right. This is right for an owner to do such a thing, to terminate the contract. So let's see what kind of provisions we have in our national and also autonomous legal sources when it comes to delay of the payment of the hire. So according to Maritime Code, if the charterer has not paid the hire on its due date, the owner may claim immediately the payment of hire contracted for the entire duration of the bareboat charter terms, or may withdraw from the contract. In our autonomous legal source, as I said, we use BERCON as example for autonomous legal sources. So according to this one, the first lump sum has to be paid on the date and hour of the vessel's delivery to the charterers, plus any delay in payment of hire shall entitle the owners to interest at the rate per annum. So BERCON is really strictly about the delay delay of payment, and also we can see from our maritime code that is really clear what is possible to do in the case of delay. Of course, payment of hire is not the only charterer's obligation. Of course, after the bareboat charter term has terminated, the charterer shall be obliged to return the vessel to the owner. So I'm talking about redelivery or returning the vessel. So in the event of charterer's failure to return the vessel to the owner, according to Maritime Code, for the exceeded time limit, he shall be obliged to pay a double sum of original fee. So our Maritime Code is really strictly about this failure of charterers. Plus, the charterer's obligation is to return the vessel, of course, in same condition and at the same place as the vessel originally was taken over by the charterer. So, of course, condition of the vessel and the time of redelivery is also really important. Also, what kind of provisions we can find, for example, in BERCON? So BERCON provides few or several solutions in terms of place of return of the vessel. So the owners shall, in this case, according to BERCON, have the right to repossess the vessel from the charterers at her current or maybe next port of call, or at the port and place convenient to them. So BERCON provides several solutions in the subject of redelivery of the vessel. Of course, this kind of legal relation between owner and the bareboat charterer, so this type of contractual description implies a lot of responsibility of each party. For example, owner is responsible in the event of no option for use of the vessel. So unseaworthiness condition is really serious serious when it comes to bareboat charter. For example, what we can find in our maritime code, in our Croatian maritime code, is following. So the damage incurred due to defects that make the vessel unseaworthy or reduce its capacity for the contracted or normal use, plus which existed at the time of delivery of the vessel to the charterer, is next. So there is a owner's responsibility for that, unless, of course, there is always some but in these provisions. So unless he's able to demonstrate that such defects could not have been identified with the exercise of due diligence. Of course, there is a question of force majeure, but in these cases, we will see what will happen in the case of redelivery of the vessel, and we will see that problem with respective perspective of charterers. So the owner shall always be liable for any defects that the owner was aware of or had to be aware of, and which he could have identified in the exercise of due diligence. Also, charterers, he has a lot of responsibilities. First of all, he is responsible for the loss of the vessel. This is really serious problem. So in the event of the loss of the vessel caused by the fault of the charterer or maybe master of that vessel, the charterer shall be liable for such damage to the owner in compliance with our provisions from our maritime code on the ship operator's responsibility. So the charterer will not bear the damage for the vessels due to the force majeure events, but in such cases he has demonstrate that force majeure is direct cause for the loss of the vessel. Of course, there is also a question of insurance in the case of loss of the vessel. So in the event of loss of the vessel, all insurance related payment shall be received by the owner. And in this standard forms, we can also find and other details and our obligations of each contract parties. But at the end, I would like just to make a short conclusion. As you can notice, this contract is different from time charters, other time charters, other charter parties, I mean time charter, voyage charter, and so on. It is one legal form of charter parties. There is no uniform international regulation of bareboat charter, but we have in practice use of internationally accepted forms. As I said, we have owner on one side, bareboat charter. As I said, it's better to use term bareboat charter than not just bareboat, and not just charterer, because it could be charterer from the time charter contract. And each of these parties, they have so many rights and so many obligations. We can see that from the BERCON standard form. There are certain terms and also conditions that are fundamental, really fundamental to any bareboat charter. If I have to choose one on each contract party, on each side, I could say that the owner's principal obligation is to deliver the vessel to the charterer, and of course for charterers it's really important to pay a hire without any discount, without any late in the payment. Also, this kind of legal relationship, in this kind of relationship, we have so many responsibilities of each party. And finally, bareboat charter is really interesting, I could say it, because this could be good solutions for the parties in the cases when it's really not possible to buy a vessel or to build a new vessel. So this could be good opportunity to supplement an existing fleet for the charterer / ship owner in this case. Thank you very much.